to order. We have one item on the agenda today, and it's public hearing for code amendment AZ-164.24. I will read the opening chair statement, and then we'll go through the procedure for the hearing today. Okay. Persons who wish to provide testimony may do so orally or in writing. Testimony and evidence must be directed toward the applicable criteria. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes an appeal to the Land Use Board of Appeals on that issue. Please sign the sheet in the back of the room or make a note in chat if you are participating via Zoom. If you would like to present testimony, please speak only when identified to the chair by giving your name, spelling of your name, and give your address. If you have exhibits for our consideration, please provide a copy to staff. If you would like to request the board hold open the record or continue the hearing, you must make that request before the public portion of the hearing is closed. That concludes the introduction. I will begin with the first item on today's agenda and call this hearing to order. So the hearing is AC 154-24 zoning ordinance amendment. Now, the first thing I would do is call for any abstentions or conflict of interest. Any board members have any?
No, but I think that we need to declare or ex parte contact and that the AWS had a meeting with us and we discussed, some of the changes and concerns that they had, but it hasn't influenced the decision. We're going to make it unbiased decision.
Yeah, and I will repeat the same thing. I met with AWS on this and they expressed some concerns on this.
As did I.
Okay. All right. Okay, we'll start with our staff report. Jennifer. Oh, Jamie. Okay, you did.
Thank you, Chair Fikes and members of the board. I appreciate your time and taking the opportunity. I know this has been a long process. It's been going on longer than I've been here at the county, and we should have thought of Kate because it's over, I think, a year old now about this. So Tamara started this process of updating Morrow County code, and it was continued. The Board of Commissioners had remanded it back, a portion of it back to the Planning Commission, which was a portion dealing with how we think about data centers, how we do land use review, how we do site plan review. And I think there were a lot of outstanding questions and procedural concerns. And so we as staff went back to the Planning Commission, had another work session, and then had a series of meetings and consultation with some of our largest development groups, and came back to the Planning Commission with an initial draft. That hearing was actually continued with further conversation, and the recommendation that you see before you is, a long time in development. We spent a lot of time on it, a lot of time with our attorneys, and we're really proud of it. I think it reflects a more modernized way to process permits generally when we look at how we do, how we make land use decisions now versus how this code update proposes land use decisions be made. I think that we are adding a lot of clarity, taking out some of the subjective considerations in those administrative decisions and making it more clear which pathway a specific development is going to go. So a lot of our, we're going to go through a PowerPoint that outlines the specific changes we're making. But as a whole, our primary objectives with this code update were increasing the clarity about our process, adding more specific standards so that we can get to the heart of what we're actually looking for in the land use review, and then making sure that the code is consistent with state law. Again, there was a lot of public participation. There was a lot of interest in the code update, and I think we've done a really good job of finding like a middle ground that works in our view to support both staff's needs for what we're looking for, supports the state's requirements, and also meets the needs of development community. But as Matt said the other day, he said, what is a middle ground if not a minefield? And I think that that's kind of true, that there's been a lot too of considerations where I think we ended up with a product that isn't making anybody perfectly happy, and that's our goal, right? That's perfectly fine. In the Planning Commission hearing, in what they had adopted was primarily in line with what staff had recommended, and there's one specific change that they added at the very end that we can get into If you want to pull up the PowerPoint, we can start there and outline the series of amendments that we are making. And feel free to stop me at any time if you have questions. This is a big packet and there's a lot here. So please stop me at any time if you need clarification or if there's something that you have questions on.
Yeah, in a second.
And our land use attorney's on the call as well. Help with any.
It's gonna be easier to do it to you.
Oh, pressure. Okay.
There, like that. This is just hidden by. Oh, on your laptop.
If anybody wants a paper copy, I can run a few more. I'm sure where the whole did you want a paper copy?
Yeah, it's up there.
Oh. Okay. So, we put this slideshow together, help kind of, give a visual and guide the updates again. If you want to go to the next slide. So this is an overview of the amendments we're going to get into. The first one is clarifying the administrative process versus the ministerial process, separating them and moving development applications to Article 5. So those specific provisions they were thrown in at the end of Article 4, which is like supplementary items, and I felt it was more appropriate to have them as a standalone article. The second piece is language clarity and consistent terminology. This is just like changing county court to the commissioners and those types of consistency things. Amending section 10 to reference the code enforcement ordinance, whereas currently we have a separate set of code enforcement provisions that were in some places redundant and in some places inconsistent with our general code enforcement ordinance, and so we found it helpful to have consistency there. The fourth is a provision that allows the conversion of specific eligible existing dwellings on EFU land to be converted to non-farm dwellings, which is mirrored off of Umatilla County's code. Number 5 is to specify vesting requirements and extension processes. This piece was our code currently had a little bit or has a little bit of unclarity about how many times that staff can grant an extension or what vests a development application. So we're cleaning that up. Number 6 is along the same lines, clarifying the comment period and the period, and then also, and we'll get into it a little bit more, changing our process for certain land applications, land use applications. Number 7 is a discussion about the conditional use permit process. And in this one, and we can get into it more, but the intent is that whereas before we only have 2 sections in each zone, it's either allowed outright or allowed subject to conditional uses, and we keep the conditional use permit process, and we felt that was inappropriate for a lot of the applications we were receiving. And then number 8 is sort of a series of additional amendments that we can get into on other sides. So this piece is, I want to kind of harp on it a little bit, but what it's significant because, like I had said before, our code is set up to have uses allowed outright and uses subject to conditional use permits. And in previous amendments, Tamara had added the administrative review process into the code, but it wasn't really clear which actions were subject to that process. And so we're breaking it apart and making it clear and making it in alignment with state code that ministerial decisions are not land use decisions. This is a zoning permit, a building permit, a land use compatibility statement, something that requires no discretion, no notice, no hearings, and they, by state law, can only be made using clear and objective standards. So this might be setbacks, building height, but anything that requires subjectivity, like a traffic impact analysis or environmental concerns, anything like that has to go through a level of review that allows for public input, even if it's not, that's just giving notice to adjoining property owners. And then the, second level is administrative decisions, which are land use decisions, that's a state definition. And in our code, we're going to be calling those site plan review, for a development permit that triggers an administrative decision. This also applies to minor variances, land partitions. These are staff decisions. We don't go to the planning commission, but they do require public notice, require us to write findings justifying why we made the decision we did, and provides an opportunity for public comment. Any decision that requires even a little bit of discretion or interpretation has to be done at that administrative level. I have some visuals too, if that's helpful. But these are the three levels of application types and processes. So from right to left, the ministerial decision, such as a zoning permit, only involves clear and objective standards, and the planner makes a decision without notice, without hearing, without offering public comment. And again, these can only be done if it's a completely clear and objective process. The middle category is administrative land use decisions, and in our code, these are going to be called site plan review. Different jurisdictions call them different things. Land partitions, PLAs, and minor variances also go through an administrative process. This allows currently a 30-day comment period, 30-day completeness period, and then the planner writes findings responding to code criteria. Notice is sent to affected agencies, and then we send that notice with our findings, showing the public what we were doing. And then there's a 21-day comment period where neighbors and agencies can request a hearing, and then we make a final notice of decision, and then there's a 15-day appeal period. So we'll get into the changes we're making on that piece of it in later slides. But for now, that's how the process works. And then the quasi-judicial process on the far left, these are conditional use permits. Also, major variances and subdivisions go through this process as well. Similarly, it does have a 30-day completeness period where we request more information from the applicant if necessary. The planner writes draft findings. The notice is sent to affected agencies, neighboring property owners, and published in the newspaper. And then there's a planning commission hearing to address it. And then after the hearing, the planning commission makes a final decision, and the planner then sends out the notice of decision. And again, there's a 15-day appeal period. So the majority of my, that's fine, yeah. The majority of the work that we've done on this has been to really hone in on the administrative decisions, because we feel that this is sort of the most appropriate category for much of what we do. Some of what we get, it's ag land or it's residential dwellings, and those fall typically into ministerial. It's more of the clear and objective standards, but a lot of what we do falls into administrative, where there's a little bit of subjectivity, and it does require some degree of public participation. And so we focused a lot on the administrative category. We didn't focus so much on the conditional use permit piece in terms of changing the process at all. But on the following slides, we can kind of break down what our new process is going to look like for administrative review. So this would be site plan review. But again, some jurisdictions call it a type 2 decision. We would request certain submittal items to verify our criteria. Then after that site plan review process goes through, similarly, which we'll get into, I guess, on the next slide, then we'll also require a zoning permit, which is, again, a type 1 decision to ensure that that project is consistent with the clear and objective standards and any conditions of approval after the subjective portion of our review is done. And then they'll go through and get a building permit through this boardman. Yeah. Zoning permits are ministerial permits that serve 2 purposes. So if it's a use that's allowed outright, say it's like a farm building on a farm in the EFU zone, all we're really checking for is like setbacks and like consistency, basically that it's an allowed structure in that zone. It's clear and objective. We're confirming that it meets the clear and objective standards. It doesn't require public notice. And the second piece for zoning permits, though, is something that has already gone through a subjective review, either a site plan review or conditional use permit process. And we've had conditions of approval. So maybe we're saying you need to get a access permit, you need to get confirmation that the your plan for water is sufficient, whatever those conditions are. You need to show us that those have been met, and then we will issue a zoning permit. And that's the that's the checklist on our end to tell the building department you're good to grant building permits. So that's our last stage in the zoning permit process. So how do we determine whether something should be in this review? These were the triggers that we came up with, and that are included in this code update. So any uses that have specific standards or limitations that require sensitivity, development that requires a traffic impact analysis, which in our code isn't hit until they're generating 400 trips per day, in addition to what's already impacting that street system. Development, this one's a little bit complicated, and I'm sure we'll get more into it, but if a development uses a municipal sewer system, that the development is outside of an urban growth boundary, there are state laws and requirements around the definition of urbanization, and that plays into our review, so that definitely requires a higher level of analysis. Development within specific overlay zones and applications that include variance. I think we might have actually taken out the variance piece, since that's separate application. I don't remember if it's still in there. But the long story short is that any application that requires subjectivity on our part, we are going to be sending out for notice in accordance with state law. And this is also important because if we don't give enough process, so if we take something that does require subjectivity and we don't put it through the process that the state dictates, then the way that the state views it, if that project didn't really go through the proper process, a neighboring property owner or somebody who was adversely affected can appeal it, not just within a specific appeal period, because there was no appeal period that was ever started. They can appeal it not indefinitely, but for 10 years or something, depending on the project. So we want to be careful on both sides. It's really important to give enough process to protect everybody from lengthy appeals that are based on us just not doing the process the right way. Any questions on that first piece? Okay. So the second piece is language clarity and consistent terminology. This is pretty straightforward, removing references that are no longer in effect, like Secretary of the Planning Commission or County Court. And the other one that we're removing is references to site development review, which was an old process that was triggered based on the acreage of the site. So instead of like in this version, in this code update, we're saying, you know, if it requires subjectivity or if it hits a certain traffic threshold, those are cues for us to process it administratively. Under the prior code with the site development review, and this was removed years and years ago, but the trigger was 100 acres. And so we felt that was a little bit arbitrary that, you know, there can be extremely intensive uses that are operated on 99 acres or less intensive uses on 101 acres. And we didn't really feel that that made an effective difference. So that was actually removed a long time ago, but we just needed to go through and clean up those zones that reference site development review to bring it in accordance with how the code is structured today. Clear and objective language is the next one. So for anything that we want to make sure that with some of our zones, the way that it's phrased, like in the MG zone, it's currently says that a minimum lot size has not been determined, but it must be a size necessary to accommodate the proposed use. However, it's anticipated that most will be at least 2 acres. And that's driven by carrying capacity and the carrying capacity of the land. Those are all very subjective, and by having that in there, technically anything in the MG zone would have to be elevated to administrative review, because how can we make that determination of carrying capacity without subjectivity? So rather than doing that, we just took that out and said, just to make it a 2 acre minimum lot size, if they want to request a variance, they can request a variance, but we're trying to throughout the code, make it as clear and objective as we can for a typical development.
So since you hit on that one, and there's one that I have a question on.
Yeah.
Because, you know, just thinking of instances where, you know, less than 2 acres. And I can think of one instance, now I don't think it's in the county, but it's in the city of Boardman. There's a cell tower that's located on a piece of industrial ground, I believe it's brand industrial, but anyway. When the landowner sold that property, they wanted to maintain the cell tower, so they divided out basically the footprint and an easement for that cell tower. A cell tower doesn't need 2 acres. So, but, you know, when I hear that you can get a variance, then, you know, I guess that alleviate some of the concerns that I had when I read that particular issue. But
Mhm.
again, I can think of, instances where 2 acres is far more than what needed for what the use would be.
Absolutely, thank you, Commissioner Reynolds. And that's a good point. I think with this being the county code, that we are anticipating our general industrial zone to be more rural industrial uses. And there are definitely situations where 2 acre minimum isn't required. But we also, this just makes it so we wouldn't be just approving land divisions to cut up those general industrial parcels into really small parcels, if that makes sense. Because that in one sense, it's also protecting our industrial land by saying, we don't want all these tiny little 1 acre industrial parcels. We want to have at least a minimum 2 acre lot size to allow future development moving forward. So it wouldn't preclude you from putting a cell tower on a larger lot, and it wouldn't preclude you from using a lot that currently exists under those 2 acres, because it would be an existing non-conforming use. It would just make it so that we're not responsible for determining the carrying capacity of the land in order to make a determination of whether or not partitioning a general industrial parcel to a smaller lot would make sense. Does that answer your question?
Well, kind of, but I guess I think of the piece of property where 730 and 84 come together. That was general industrial. The landowner there had a billboard sited on it. When he sold that property for the sake of bargaining, say he wanted to maintain receiving that contract for that billboard. I would hope that, he wouldn't have to cut 2 acres out of there to do that. The carrying capacity that's needed for that billboard is basically the footprint of the billboard and enough room for the billboard company forever to change out the banners.
I guess I have 3 responses to that. The first would be that we would consider that to be an existing non-conforming use. It's already existing on a lot smaller.
But it was 11 acres. The landowner sold the property and he wanted to maintain that piece of ground in that billboard, so he had a revenue.
Yeah, I'm not sure if there's a mechanism for him to have a lease on that or something, but I think generally when we look at land use, we want to be careful that we're not carving out a piece of property that could only be used for a billboard, if that makes sense. So if there's ways to understand like that we're protecting that parcel for not just the use that exists today, but also making sure that in the future it's a redevelopable parcel. It's not just stuck with a little sliver of land that could only be used for a billboard, for example. So I think that that's where it gets into the difference between like the use versus like subdividing that parcel. And I'm not sure if there's a mechanism for him to structure a lease agreement that would allow him to continue collecting revenue from that. But I don't know if you have another response. But I think that we would see that as not as a reason we would want to approve a land division for like a micro parcel to accommodate just the billboard.
Yeah, I think that's right. But they could apply for a variance for that specific example. But Daisy's right. We look at not just the existing use, but what the future use would be. And if you create a 1/4 acre parcel and they sell the rights for that billboard and that billboard location, because there's a limited number of those that are allowed, then what use is that 1/4 acre? And underlying zoning wouldn't be changed, just a 1/4 acre. So I think we'd have to, you usually give us challenging examples. We'd have to deal with it on a case by case and either suggest a long-term lease or apply for a variance, which the planning commission can look for.
Yeah, so other examples of clear and objective language, we have a definition for like utility facilities necessary for public service. This is something that was brought to our attention by Unitil Electric Company, where they said, rather than saying utility facilities, that's so broad and it's not defined, please make it a little more clear and what you're actually allowing them versus what would be required to have a conditional use permit, for example. So we just went through in those places where it wasn't defined, tried to make it a little more clear. And see, yeah,
The term, that term is consistent with statute.
yeah, making it consistent with statute. And then this piece is with, we'll get into it on a future slide, but the expiration dates and when we're able to, extensions. Is that more clear and objective? Yeah, so this is where we're removing subjective standards from zoning permit review, which as it's written, there are certain pieces of our zoning permit requirements that require subjectivity. So one is the lot area shall be adequate to meet the needs of the establishment. We're striking that and replacing it with that it meets the minimum standards of the zone, which would be like that 2-acre minimum. Number 2 is development and hazard areas identified in the Morrow County Comprehensive Plan shall safely accommodate and not exacerbate the hazard. Obviously, that's super subjective. So we're taking that out, but if it is in the hazard overlay, those standards still apply. Site planning, including the siting of structures, roadways, and utility easements, shall provide wherever practical for the protection of trees 8 inches caliber or greater. This is like protection wherever practicable. We felt that was subjective for the zoning permit review. And in this case, we didn't carry that tree protection standard over to administrative review because it's not something that we've really implemented before, and we don't require applicants to show tree protection on their site plan. And this one's open for discussion. I think that there have been times where developers have said, oh, like what's the process for removing 8 inches of caliper in diameter? And we're just kind of like, we don't know. We don't have an arborist on staff. We don't have anyone who can make that subjective determination of whether tree protection is practical. It does have an exception for noxious or invasive species, but we don't really have anyone even on staff that would be able to make a professional determination of what a noxious or invasive species is under that definition. So the 4th one on this list is also compliance with the significant resource overlay and the historic buildings and site protection, which again, similar to item 2, would still be required to meet those standards. But in our zoning permit review, we don't think that's a clear and objective standard. This one we discussed, we're amending section 10.030 to reference the code enforcement ordinance rather than having violations and nuisances and criminal penalties like defined separately in the zoning ordinance. This is a clarification of our extension investing requirements. Expiration dates, if it's an SPR or CUP, the approval is valid for 2 years. If it's a dwelling in the farm report zone, it's valid for 4 years. So that means they have to get their building permit within that period, or they have to get their zoning permit within that period, and then they have to get their building permit within a year of that zoning permit being granted.
So why the difference in years for different?
It's the farm forest zone expiration date is statutory. The 2-year approval is at standard, but in the EFU and farm use zones, the state has a longer expiration date. So those are remaining.
And remember, both of those you can add a year or 2 years, so you'd need to qualify for your zoning permit, and that can be extended a year as well. In a farm zone, you usually don't have very many neighbors, so it's not usually a concern to have a permit valid for 4 years before they start building. But in other areas, more densely populated areas, neighbors in particular want to know if they've gone through the permit process. They want to either see it developed, or if they sell their property, it's only valid for the 2-year period of time.
So an example, like for the timeline would be if you got a conditional use permit to develop an industrial building, it's as long as you apply for your expiration or for your extension prior to that 2-year date, you can get a 1-year extension, and we've made it a clear and objective extension. So as long as the code hasn't changed, you've applied for it prior to the 2-year deadline, it's granted automatically. That's one of the things we're changing, so that it's where prior you would have to show that there's reasons that kept you from being able to develop it, or there was some subjective analysis there. We've just made it clear and objective and said you can just get an extension as long as the code hasn't changed. So the director can grant a 1-year extension, and then those, as long as you get your zoning permit prior to the final date, of that, extension, then, you're good for a full year. That land use decision is vested, so even if the code changes after you've received your zoning permit, it doesn't matter, you can still develop what you're, trying to develop, and then that zoning permit is vested when the building permit is granted. Our current administrative review process, as I mentioned before, it's a 30-day completeness period. Then we draft findings, we send out the findings, we allow a 21-day comment period. If a hearing is requested, then it would go through the quasi-judicial process where we send out public notice of the public hearing. If not, the decision would be final after that 21-day comment period, and then we'd send out the notice of the final decision, and then there's a 15-day appeal period. So currently, any administrative review process often takes longer than our conditional use permits. So if you have two applications and one of them is going to the next planning commission hearing and one of them needs to go out through this whole process, it's often more timely to just send it to the planning commission than it is to go through a 21-day comment period and potentially have an appeal or a hearing request, and then a final decision and then a 15-day appeal period. You're sometimes better off just going the planning commission route. So we're changing this. If you want to go to the next slide, I'll show you what what the planning commission has recommended. So we're keeping the 30-day completeness period. That's again, it's a statutory requirement. Then we'll issue notice of the application to the neighbors and agencies. So we don't need to go through the process of drafting all of our findings before we even send out notice. It's just a notice, just like we would with the conditional use permit, say, hey, this is what's generally being requested. Let us know if you have any comments or if you'd like to request a hearing. We give a 14-day comment period. If a hearing is requested, an additional notice would be sent out. If not, the decision would be final after the comment period. We'd send out the notice of final decision. And then a 14-day appeal period. And then with that too, the other thing I wanted to add to that is that there was one note that in our code update, what was recommended, the initial hearing, we want to make sure that it's put as a de novo hearing. So it's any new evidence can be presented at an initial evidentiary hearing. That's also in line with state law. So that was brought to our attention and we are updating that. And that's on that's on Article 9 administrative provisions under appeals. We have it in your packet as striking the but not limited to the record of the decision being appealed. But we are actually going to be keeping the but not limited to piece in there. And I think that covers our basis for allowing that as a de novo hearing, which again means that anyone can bring new evidence or testimony, or people who haven't participated in the process can participate at that point. And this is what I just said. This image on the right shows what we are recommending. The piece on the left is how it's currently structured. On the right is how we'll do it. We'll write findings typically during that comment period, or shortly after, and then that notice of decision goes out. And then there's only a 14-day appeal period. So we're keeping I think that makes it a little simpler. Instead of like 21 and 15, it's just 14 and 14. So we know it's 2 weeks, and then that also sometimes, like if it falls on a Saturday, there's been confusion of like, does it end on the Friday or the Monday, right? So we're just gonna say 14 and 14. So if we send notice on a Wednesday, then it's finalized on a Wednesday, and it makes it a little bit more clear. Okay, so the CUP recommendation is the inclusion of the middle category of uses that are allowed subject to administrative review. So again, the administrative review piece has been added into our code in prior updates, but our zones still have it as either allowed outright or subject to CUP. And so we wanted to make sure it's really clear that we break that down and say, okay, which items actually require that middle ground, which is not quite the level of a hearing, but also they're not clear and objective standards. The CUP criteria are more subjective, but the hearing allows an opportunity for public input. This is where I want to make that note that the planning commission, during their review at the August hearing, recommended that data centers be recategorized as a conditional use. And this would allow the data center use to be reviewed more holistically, because those conditional use criteria are more subjective. if you've had a chance to look at Article 6, it breaks down the actual criteria of CUP. And thankfully, some of our members of the planning commission are here to speak to that decision and why that recommendation was included in addition to what staff have proposed. So I think that's helpful to have their voices in the room to understand that that perspective as well. And then these are some additional things that we have in there. The first is like what I mentioned before, conversion of an existing farm related dwelling to a non-farm dwelling. So often if you're, you know, wanting to do estate planning or, you know, you don't want to use your, you don't want to have this as a farm parcel or farm dwelling anymore with all of the standards that come with that. We allow a process to convert it to a non-farm dwelling. This accessory structure piece was actually recommended by a prior board of commissioners, I think in like 2018, that they wanted to have shipping containers as an allowed use, and they wanted to have certain criteria that it has to be painted to visually conform with the surrounding environment and so forth. And we wanted to make sure that's really clear that it is allowed, but we also added a limit that no more than 2 shipping containers could be allowed on a single lot, which I know there's some challenges with that. Obviously, a 3,000 acre lot is different than a 1 acre lot when you're looking at how many storage units might be appropriate for that site. But it was just what we put in there is like a reasonable number, what felt like a reasonable number. And then shipping containers can't be used for human or animal habitation and has to conform to local and state building codes. One thing I do want to mention on this slide though is when we talk about clear and objective standards, painted to visually conform with the surrounding local environment isn't clear and objective. So when the prior board had adopted that language, it wasn't put into our zoning code, but it was adopted by resolution or ordinance, if I remember. And so I kept that language because it was what was adopted before, but based on this, we would have to do administrative review for any shipping containers that are proposed, which isn't a huge list. It's the 14 and 14. It's just notice to neighbors, notice to affected agencies, and a little bit more time on it, but kind of just like food for thought about when we think about how our processes work, and how we think about clear and objective standards, that would actually require notice neighbors, which may be appropriate too. If their neighbors have concerns with shipping containers, it may be worthwhile to have that criteria. But this is how our recommendations currently structured. Okay, that's what I have.
So back on that one, accessory structures, zoning permit for 100 square feet. What's the state requirement for a building permit?
120.
So why aren't they consistent?
It's a good question. We also, I think it goes back to some prefab manufacturing. We also permit a use, so technically, if you change the use of a structure, we would require a zoning permit. And building codes wouldn't require anything unless it's a commercial structure. It's just, that wasn't something we changed in our code. So it's been that way for a long time. We're not changing that part.
Any question? During this hearing, the staff or planning members, I guess, they're going to elaborate on what went through there, how it ended up moving data centers into the city. That seems not very clear in the process that went into doing that.
Yeah, so
And the rationale so forth.
yeah, I might have to speak more to the history because I think that was brought up initially as in a very preliminary work session as an option that we should explore. And we didn't really vet it. We didn't really look too much into it. We pursued the administrative review route and tried to make the standards in the site plan review portion in alignment with what we felt was appropriate to accommodate a more intensive use. And during those discussions that we had outside of public hearings, but just as we developed our code amendment, we didn't really look too much into it. And when we brought it back to the planning commission, there was that question raised of, you know, kind of what are the pros and cons and why wasn't, looked into as much. And we also have Dan Kearns online to speak more to some of the pros and cons. Our land use attorney, Dan Kearns. But I don't know if someone wants to be part of the history or the rationale.
Yeah, we did address it over a year ago when we initially had a work session. The planning commission at that time didn't make a formal recommendation to move it into one category or another. So I didn't follow up frankly on the conditional use piece beyond that. But we did have some further discussions about it. I don't remember exactly.
That was initiated by staff.
The conditional use option,
What you just said about it, having a work session, that was initiated by staff.
the work session was initiated by staff with the planning commission. Yeah,
Well, at that point, can you give me the rationale for doing it at that point? Why?
oh, yeah, and Dan can help you with this too. A data center by every measure is an urban use. And the places where we're proposing them primarily are in rural areas. They have significantly more impact than would be a 5,000 square foot manufacturing shop. Based in terms of impacts to water, wastewater, sewer, electricity, etc., roads, structures, they all require a traffic study. They didn't initially, I'm not exactly sure why, but 5+ years ago, they didn't have a traffic study.
Right. Where did you get the statement that they are urban use? Are they all in urban areas in Oregon and all the other places that they're located? How did you? That seems to me to be a subjective statement right there. That they're, and who came up with that statement?
So that's off the cuff from me, but I can tell you in goal 14 and based on old case law, the safe harbor, which is the minimum for rural uses versus urban uses. I think it's 5,000, anything over 5,000 square feet is considered urban. Similarly, in a residential area, any lot that's smaller than 2 acres is considered an urban density. Any lot over 2 acres is considered a rural size. So I right now can't recite where those are, but it's either density or parcel size. There are some safe harbors implemented in statute and some otherwise. But so for example, we have in our code a rural industrial zone, and then we have a general industrial zone. And in a rural industrial zone, I'd have to pull it up, but it has to either be a rural nature or it has to meet a threshold size, a minimum size of the structure.
But the one we're talking, you're pulling it out of for industrial, or you're pulling out of an industrial zone and making it a CUP, where there's all kinds of other things that are allowed outright. Well, the industrial zone is not an agricultural zone, it's an industrial zone.
Right, and industrial uses are listed in the port
Yeah, so
industrial zone.
you were trying to say that they're more in the rural area, but these are in industrial areas. With, if you look down at all the other allowed uses, I really want to dig down and find out how this all came about to pull that particular business type out of that zoning. And
Honestly, it's the only highly urbanized large development we've been dealing with in Morrow County that's outside of the city limits or an urban growth area.
I still don't understand how the term urban development came in.
I'm a professional urban planner and I'm falling short. Dan, do you want to help define?
Yeah.
I mean, what's the threshold besides, and I know there are safe harbors. Do you want to help with this one?
Yeah, this is a discussion about data centers?
And Chair Sykes is not clear why I'm referring to a data center as an urban use rather than a rural use.
Okay,
Or
so it's a discussion about
Industrial
data
zone,
centers.
Yes,
You're pulling it out of industrial zone, not a rural zone. It's
two different things, if I might. So we're not changing the zoning. or where
No.
data centers are
But
allowed.
you just require, you're pulling it out of a group of businesses that are allowed use in an industrial zone. You have allowed use in industrial zone, then you have a list of it,
Mhm.
and you're pulling that out and then calling it a urban use.
Well, we actually don't define it as an urban or a rural use. Our common reference for a data center, I don't know that you would meet a planner who would say a data center in any zone is a rural use. It's a very large urban scale development.
Or industrial.
It is industrial, but the scale is urban, not rural. Rural is the little widget factory, or it's a house on a farm zone.
If I
Tijuana
might,
or a mill site is
if
a
I might,
rural use. Yes, please, Matt.
this urban rural distinction arose in the early part of the Oregon land use program. And so today's uses are, it's kind of difficult to fit them into that original construct. So what Tamara mentioned about size matters in determining whether it's urban or rural, that's kind of a residential notion. When it comes to industrial type uses and determining whether they're urban or rural in nature, it's far more subjective, and you have to kind of look at the basic nature of the use. And remember how the Oregon land use program began to protect resource land for resource uses. And so Tamara's statement that data centers are inherently an urban use, they're certainly large scale, intense uses, but you know they're not rural because they don't serve rural needs. If this was a data center for farm data, that would be a closer question. This is not, it's not related to rural uses, it's not related to resource uses, therefore it defaults to urban, and it can be allowed out on unincorporated county land if there's an exception taken, which is usually the case for these rural industrial zones. So that gets them off the hook of having to comply with goal 3 or goal 4, the resource zones, but they're inherently urban in their scale and intensity and their lack of connection to rural or resource uses. So, I mean, that's how they fall into that category.
So I guess I have a comment there is that we seem to be calling data centers and thinking of the one company that we have now.
Mhm.
In applying that concept to the term data centers or type of industry, I mean, you could have a much smaller data center that'd be a quarter of the size of one of AWS's buildings now. It'd still be a data center. And it doesn't have near the impacts, but subject to the same standards. Seems like a disconnect to me. And to say that they don't serve rural uses, you know, who knows what the use of that data center is, who's their customer are. I've been told that, you know, one of their customers is Netflix. I live in the county. I use Netflix. We don't know that Morrow County Grand Rivers doesn't have stuff stored on a data center somewhere. USDA serves rural uses. I mean, I can go on and on. There's all kinds of rural uses that will use a data center. So.
And I think it's the primary market. So there is a lot, like the Curry County case, which was a landmark case, which changed all the counties across the state had to amend industrial and residential zones from them. It's not just the size, as Dan said, it's the intensity. And is your primary market maybe 51% or more, the rural area in which you are located? Certainly not for a data center.
So Tillamook Cheese is not within the city limits.
No, but it's
It
in the
is
Port
yours.
Industrial Zone. So, and the
So
Port
why-
Industrial Zone has a goal 11 and a goal 14 exception.
So again, if it's in the port industrial zone,
Mhm.
why would the data centers be a conditional use permit, but Tillamook Cheese, Lamb Weston set a processing facility out in East Beach, not? Why would they be an outright use and not a conditional use? The impacts, the strain on resources is all the same.
What I detect is this, why conditional use as opposed to outright? And I had kind of the same conflict in my mind too, when Because when I looked at these code provisions, it's totally through the lens of data centers. And the discussion about data centers, wherever you allow them, in whatever zones you allow them, it should be very clear that they're allowed. So I would recommend whatever zone it is, there can't be really a dispute that they're allowed or not. And the theory of conditional uses is that it's an outright allowed use. And the question in a conditional use permit application is what conditions are appropriate to mitigate the impacts of that use, because conditionally listed uses are uses that are hard to guess in advance what the impacts are, and therefore formulate the mitigating conditions in advance. So they're a case-by-case evaluation of the use and what the impacts are, so you could fashion conditions. So as we went through these data centers, that's what it was. That was the evaluation. It wasn't whether they should be allowed or not. The zone, in my view, clearly allowed them, but rather an evaluation of conditions to mitigate their impacts. And for data centers, the only impact that I'm aware of is impacts on transportation facilities, because I was surprised to see they're huge trip generators, but also you have so many of them. The collective impact of all these data centers on the traffic system causes a number of significant intersections to collapse to a failing level of service. And so you just need a process to evaluate those impacts so you can fashion basically a transportation mitigation condition. That's why data centers have to go through a discretionary process. It's not like check the box, is it commercial, yes or no? If it is, it's allowed outright. Data centers have impacts that you need to mitigate, that you need to make sure that those transportation impacts are taken care of. And that's why they're in this category. You could do it either as a conditional use or through a site plan process, either way. But you need to have a permitting forum for fashioning that kind of condition.
Like to me, like you're trying to assign, for instance, increased traffic usage all to data centers, when you have increased residential, you have increases all over the place, and you're trying to say, okay, the traffic change increase is what you're saying is attributed to this data set. And where I don't, I mean, like I said, you have new apartment complexes, you have, whatever else, new.
Landless.
Yeah, you have a whole bunch of other things.
Right.
To just
These
just assign a traffic change to one particular industry seems a little bit.
no, it's these uses are big trip generators, and the transportation studies that are submitted with them demonstrate very clearly the intersections that their trips cause to collapse. They're not near residential areas. They're out in port industrial. They're away from residential areas. So those are not traffic factors. It's these uses that the traffic engineers have determined generate the trips that cause the significant failures of these intersections. So that's why those are the target for these conditions to mitigate. Otherwise, there's no source of funding to mitigate for these impacts. I mean, the port doesn't have money to do this. The county doesn't either.
So if you go back to the very beginning, a year ago, when it was brought by staff, you could attribute them approaching this and thinking about it to the fact that they're saying that increased trip usage is caused by these centers. Is that the driving factor behind you doing this?
Sure, so to be clear, if a Lamb Weston or any facility, any development of, I think a 60-unit apartment complex hits that threshold, like it's anything that hits a 400 trips per day threshold would require an administrative review, a traffic impact analysis, and a full process. And if they do trigger, if they're the straw that breaks the camel's back on an intersection that's close to failing, that development cannot go through until they fix the road, until they fix that intersection, until they, like, whatever is required to make it not a failing intersection. We cannot permit that development until they do
Okay,
that.
did you see that straw on the camel's back right before you were, did you see that because of the data center?
So I think what Dan's trying to maybe say is like that a lot of these developments, we can't really anticipate what's gonna come in or what types of industrial development or what types of farm development might potentially be that straw that breaks the camel's back. But this is one use that we've seen growing and we've seen that has had significant traffic impacts that we can say that's more than a straw, right? That we can take a look at it and say, this is a use that maybe, and again, this was not part of our initial proposal or part of what was developed by staff, but the theory behind it in terms of the holistic review of certain uses would be to say, let's take a look at this through the lens of a comprehensive use or as an conditional use in order to think more holistically about the impacts.
Okay, that's currently, but I'm going back, circling back to a year ago, before you were here, when they originally started this conversation. I'm still trying to find out why, what triggered that and why was that brought forward? The original plan to have, what we say, hold a work session and bring it
Yeah.
before the planning commission.
Yeah.
What caused you to do that?
Yeah, I'll take that question, Chair. We knew that calling it an outright use was very misleading to the development community, and we had work sessions with AWS because we would get their primary contractor and multiple subcontractors, different design teams, different engineering team. They read our code. When it says outright use, they think they come in and we sign a permit and they walk out the counter, and that's not the case. Because as Daisy explained, well, that any decision that has discretion requires findings, which you're familiar with, and a notice, and an outright use does not typically. So we said, let's make our code abundantly clear, so when AWS or any developer is working in the community, they can pick up our code and understand what the process is. That's also why over the past year, we have included this nice little flow chart that Daisy has. So for example, today, if Lamb Weston wanted to build a new plant, we would require a traffic study. Likely they'd be over 400 trips per day. And if it's an outright use, we wouldn't be able to, it's not a clear and objective process. We'd still have to write findings and provide notice. So, we could actually go back and look at other uses in industrial zones, but we're not getting a lot of other industrial uses, really just data centers.
Yeah, but you're not moving Lamb Weston over. Why not just, if you just use them as an example, why not leave the outright uses where they are and then just apply what you just said that Lamb Weston would have to go through to the data center?
So we did, and actually the development community and staff have met numerous times over the past year, and we've all agreed that it'd make more sense for the code to be clear about that.
And since traffic is the issue, the 400 trips, average daily trips is a good trigger. But also, Chair Sykes, go back even farther than a year ago when the first data center came in. I assume it was a campus of 5 buildings, and we saw it was a certain trip generator, but it didn't warrant a whole lot of mitigation, probably no mitigation. I don't think the impact were significant to drop the level of service to failing until like the 5th or 6th data center came in. But you could be looking at, over the next 10 or 20 years, over 200 data centers. And right now, with just the few that have been applied for, ODOT has projected the failure of at least one intersection that requires, it's not the end of the world. It just requires a reconfiguration of the intersection so that it still functions and the delays are acceptable. And, that's basically a $12 million mitigation, and it's attributable to the trips generated by the data centers. And so development generally pays for the mitigation of its impacts. And that's what this process is about, so that that kind of condition can be fashioned in an open public setting. And so we've been working with AWS, and they want these intersections to work also, because if their employees can't get to, the plant then it's not working. So right now, the mitigation until the intersection is rebuilt, the mitigation is to move the shift change outside of the PM vehicle peak hour so that the shift change doesn't correspond with the peak hour and it alleviates the congestion. But sooner or later, with more and more data center applications, that's not going to be sufficient. The intersection and probably others will need to be rebuilt. And you need a process, an open public process, to fashion that condition and impose it and make it clear so that no one can then appeal it. Once you follow the process, have the hearing, issue the decision, it is not going to be subject to appeal years down the road. That's a big risk that I don't recommend you run. These facilities are super expensive, super important to you, to the applicant, to, you know, infrastructure of the country, to allow them to be subject to appeals that you don't expect could be months or years after the permit is presumed final. That's
Do you have an
what
exa-
we're
do you have
hoping
an
to solve.
example- Do you have an example where this appeal was done in
I'm
another area?
right now, I'm in Wallowa County. I was at a Board of County Commissioners hearing today, challenging a Dollar General store that was appealed 2 years after the permits were issued because the county messed up the notice and people who were adversely affected and aggrieved. That's the standard in the state law. That's pretty subjective. Found out 2 years later that the permits had been issued, appealed, and here I am today dealing with this. I've appealed industrial plants years after they were permitted because the local government didn't provide the required hearing and notice. And that's the risk that no applicant wants to run, and no local government should run that risk by scrimping on the process.
Can I add one more thing to the conversation too? Currently, if nothing changed, the way our code is structured, we have, I think, 18 uses that are conditional uses in the general industrial zone. So to take this as an example, it is our decision as a county. It is your decision as the Board of Commissioners, what you think is most appropriately handled in a subjective analysis, in its conditional use analysis. And in this case, we do have to be aware, in many counties, honestly, I think our county is the only one I know of where a data center is specifically addressed as a standalone use. Typically, they're categorized under other uses, of either warehouse uses or there's other ways to categorize. Our code calls it out specifically because in prior years, someone at the county thought that it was most appropriately handled as a standalone use. And I think that's appropriate. I think there have been examples of people overly broadly categorizing things where, oh, it's a warehouse, and then all of a sudden they're stuck with an application that they have to approve that they feel like maybe they weren't really thinking of when they initially threw warehouse into a allowed outright category. So in our currently as it's written, we're recommending putting a lot of these uses as administrative review that are currently conditional uses. So wrecking yards, like lumber manufacturing, wood products manufacturing, agricultural processing plants. These are all ones that we are moving over to administrative review to make that sort of development more clear and objective. And that's your call. If you think some of those issues, like a concrete or ready-mix plant, do you think that maybe does make more sense to be a subjective conditional use? That's our call as a county to make that case by case determination.
Well, I don't think they're talking 15, 20 minutes about a concrete one.
Right.
It's a data center that we're focused on. So, I mean, we're not talking about moving another, a wrecking yard or something. So, and my questions are about how we ended up, how you got to where you at by moving it over, and the process that was used. We haven't touched on that yet through the planning commission.
So if I might, to summarize, during the work session a year ago, staff said, just showing a data center as an outright use is very misleading. And we heard that from the development community. So be very clear about what that process looks like. It's clearly an allowed use. So when we had a work session with planning commission, we put those two options out. Someone from the development community took strong objection to making it a conditional use. it is a little bit more subjective than making it, subjecting it to site plan review. Never heard a formal motion, so as staff, we had multiple meetings, the my objective was to make sure we have the development community, the regulated community and staff at the table to come up with a product that we can all live with. We don't always make them happy, right? I mean, some development would prefer not to have any permit, right? But our job as planners and as appointed officials is to make sure that development complies with the code and it's compatible with the neighborhood, the comprehensive plan, et cetera.
No,
Right, so just to summarize, what was the impetus for having this discussion at all? And I presented them to planning commission, site plan review, conditional use. Honestly, I never got a crystal clear direction from planning commission to make it conditional use. And on my own, after those meetings with the development community said, I think it works. I think we can address those compatibility and impact issues by moving it to site plan review. And that's what we presented to planning commission in August. And planning commission said, don't you remember back when we had a work session? Why don't we make it a conditional use rather than just a site plan review? So if there are other items that come up on a project by project basis, we have the ability to address those issues. And so they made the motion, they voted to approve pretty much verbatim what you see right here. And then after that, they made another motion and also unanimously said to move data centers where they're allowed, in the zones where they're allowed, move them to a conditional.
how much public input was there when before they made that decision?
That evening, not much. Prior to that, there was
Not
a,
much, is like zero.
yes, chair sites.
Okay, I'm just trying to get how this
They had
process.
closed the
went down.
public hearing,
And
yes.
like
chair
that, I
sites.
wanted to know how the process happened,
Yeah,
so that's why I'm asking the
Yeah.
question. Okay.
And we do have, two members of the planning commission here who, want to speak during the public testimony portion about what,
Yeah.
drove their decision to.
Yeah, I look forward to talking. Yeah. That's all the questions I have. I just don't.
Anything at this time for staff, you junior?
So you done, staff report done?
That's all.
Okay.
Yeah.
Okay, now at this point, the hearing will invite the applicant and the proponent, or proponents to present testimony and evidence. So is there anyone that would like to speak in favor of it? Or,
Picture the way we presented these and we just updated that list, really anybody who's signing. It's really not pro or.
yeah, no, that's wrong. It shouldn't be pro, it should be.
Yeah.
Just the applicant get to speak and the.
And so the county in this instance is the applicant.
Right,
So
okay,
sorry if you're checking.
all right, so the county, that would probably be, I guess, planning commission, right? The applicant proponent would be, is that who's out there? Somebody from the planning commission. Okay.
I have to give all the Stacey Ekstrom, chairman of the Morrow County Planning Commission. We have started this first, thank you staff, you guys have done a great job on this, and I first have to start off, but by saying we are not, I shouldn't say we, I am not anti data centers, we are not trying to harass anybody or any of that type. We started this discussion a long time ago. And really from my take on it, we have different opinions on the commission, so I'm only going in on my half of it, is that a clear and concise, because we have a problem in Morrow County that we've had issues, and everyone at this table can agree. People don't see us as being open upfront, that our decisions are not clear. That's been county issues. And I feel like that's one direction we were going to make sure that everyone knows, that the public knows that as a commission, we're trying to protect the public, the county, the developer on all of this. And as Dan said before, the major issues that had come up too was the transportation and the fact that it can be brought back. And so for me, I'm a volunteer on this, so I learn this as I go. And so, listening to our attorneys, listening to our very competent, planning staff, it is what we move forward. That's how we decided to move forward. And so it's just making sure that everything is transparent. That is at the end of the day, that's the thing. Do I have a personal opinion? That's not because I get on this, because I'm gonna be on this commission, my personal opinion isn't what matters. My opinion of what is best for the county or the people it affects. So that is why we discussed it. We've talked about data centers, and they are separate than any other in our code. It's not like when you ask why we didn't change it on other industries, because it's not broken apart that way. And so as for how it came about, we did go through all of these changes. When we got to the end of those, then I believe at that time we had a discussion with Dan on the transportation part. Is that where I'm trying to get I go to a lot of meetings, and I know you guys too, so I apologize. And I believe that's where we then came in more about what our future issues are going to be.
And let me say that I appreciate what you're doing. I was chairman of the planning commission for 10 years, so I understand that you're volunteer and all that. So I'm not trying to, give you an example. I'm just trying to figure out how decisions, because I've been in that seat over there myself. So that's the other questions I asked. And in fact, Jeff and I were on there when we wrote the comprehensive plan, the economic thing. So we wrote that in 2014. We didn't write it, but we had all the input. And there was a lot of input, I gotta say, on that comprehensive plan. There was a lot of input. We heard people from every industry, every business, agriculture in the county, tourism and everything to formulate that, And I noticed in your introduction that it refers back to the comprehensive plan, of course, because that's what we do. And data centers or I'm sure you've read the comp plan, you know that they're referenced in the comp plan, so, doesn't match up, so. Yeah. I understand what your job is there.
Oh, yeah, and like I said,
Sometimes it's a thankless job, like I say, you be late at night.
I have a lot of this, but that's here for that I already have.
Yeah,
But that's where we, at least as I took, from our takeaway is just, we needed to make sure it was clarified and for our future. And do we have 200 data centers in the future? I don't know. That's not today's decision, but that is what we're trying to build on, that we don't have repercussions coming back. That's part of it. So that's fine. Is there any other, I'm trying to think. So that's how we came about this.
okay, thank you very much, I appreciate it. Anybody else want to speak for the applicant or opponent?
I am Mary Killian, MARYKILLION, I can board member. Again, going back over the timeline, Tamara and everybody got it correct. We've had many discussions during our meetings about data centers, as well as how they're approved and what our role is in it. And as you guys know, our priority is Morrow County. And I think it became more appealing to us as we developed more and more data centers in the county, that we have just a little bit of input on location and impact on our communities. Because at the end of the day, people are going to come and talk to us about the decisions that we make and how it impacts them. And it impacts us directly as well, impacts you directly as well. So while we are not against data centers, in fact, we welcome them. We want to just make sure that the impacts are something we can all live with for a very long time. We don't know historically, we don't have the history in the county to know what the long-term impacts are. And so we're just winging it,
Can
trying to make the best.
I ask you about the time that you spent? Was there reference to a year that you spent talking to people in this industry about them citing?
Well, we've had many applications. I don't.
An application, I thought that you were trying to smooth out the application process to,
Yeah, not a year. I
How do
don't
you-
know exactly how long. I know it's been a very long process. It's been on our agenda many times.
is that not fruitful in what you say the goal is, because the change into the CUP was, as I understand, was like a last minute thing.
It really wasn't though. That's very misleading. I don't think there's a commissioner, planning commissioner who would say that it was last minute. It's something we all have been considering. And as we went through this process, which was so thorough, and I love the fact that we brought so many industries into the process. They did a fantastic job of making Morrow County a place where people can collaborate on these codes and all the regulations. I think it's fantastic what they did. And at the end of it, we looked at it and we had, I don't know if this is appropriate or not to say on the record, but we had an application that night where we had a split vote on the approval for a data center. So our commission was split at that point. So it was pretty obvious that what we were working with didn't satisfy us all
Right.
to approval. And so we just felt like it was appropriate at that time to make it more clear and concise on what we could have input on.
What you were talking about wouldn't apply to what you were, the application you were voting. Right.
Of course not, because it would have hadn't been approved. Yeah.
So I guess I don't understand why that put the pressure on you to make a move on the CUP issue.
You mean that night? Well, I think we were
Because
looking.
that was already decided. I mean, you couldn't apply that to this
No,
particular, yeah, okay.
but we understand that this process, once we left the meeting, we would have to go into a process where it was advertised, and then we would have to have so many days between meetings to approve it again, so.
Okay.
And if we didn't have something on the agenda next month or whatever, we pushed off, so we felt like we were all, obviously it was a unanimous decision. We all voted unanimously to approve it, we all felt strongly that it was the appropriate move to make at that time. Nobody voted against it.
Okay,
And I asked, since you're a former planning commission, that you respect our decision on that. I know that this is now your decision, and I know that you have to make yours.
we need by respect, is that we're gonna approve it, everything, the way you put that.
Well, that would be great if you would, but I understand that you have to hear things out as well, but, we represent the county, we represent the citizens, we get nothing out of this. None of us can get any pay, we don't get any thank yous, we don't get anything for doing this job.
That's why I said, it's
And so when we come to a meeting and we make a decision like that, it isn't for me that I make that decision. It's when I walk out of there and people ask me, you know, why did you make that decision? Why did you vote the way you did? I can say, because I believe it was the right way to go for the county, not just for Mary.
and I can say the same thing when I live here. Because I don't have any skin in this game, you know, I mean, we also represent people in the market, so.
Yeah.
We're the same category. We all represent.
I appreciate that, and,
Yeah.
you know, you're elected, unfortunately, we're appointed, but, you know.
Well, yeah, but you still have a duty,
Yeah.
you do, I think you do, I'm not calling that into question, I'm not trying to give you a hard time, believe me.
Well,
But I think we're doing what we're supposed to. You know, it's just like when somebody comes in and presents you for their staff or somebody with a request. You know, you don't always approve it, and, you know, sometimes it's just split vote. I mean, you're just doing your job, you know, and that's what we're doing.
Okay.
It's just-
well, you asked me what motivated it, and if you're questioning my motivations, I just wanted to be clear that my motivation.
Yeah,
completely
you answered
with
the
the
question.
citizens of the county.
Yeah.
Right, thank you.
That's all.
I guess I have a question. So, you know, by going to conditional use permit, I take it you're trying to mitigate what's perceived as like possibly a negative impact. So my question would be, what is the negative impact that separates a data center from a processing facility that requires the higher level of scrutiny?
So if we were getting processing facility applications, I would be able to probably speak better to that, but we are not getting those. So since we are getting data center, many data center applications over time, they seem to be predominantly what we're approving. I think that is why it brought it to the forefront. And talk about negativity, it's not always negative, and to be honest, I think it's our job to determine if it's best use of the parcel, correct? I mean, is that the best benefit for Morrow County? Is that Morrow County's, you know, best option? Is those, do our zonings and our codes, all of that align with what is best for Morrow County? And so it only, there may be negative things, but there's also positives for having them there, so we have to weigh them all.
So, but a conditional use permit, as we heard Mr. Kern say earlier, it's basically it's allowed. It's just that you can put more conditions on them. So what are the conditions that you would see being placed on them as opposed to the processing facility?
Well, maybe predominant traffic. I mean, when you're talking about on Tower Road flow, and I'm just as an example, we have a hyper center at the end of it, then we have the 4 units going in that are currently approved at the airport area. Wow. I mean, can you imagine how that's gonna impact traffic on Tower Road? I mean, that's just an example of if one unit is over 400, I can't remember how many they said was at the 1200 per day just for the one at the airport. What's the one at the end that's a hyper center, which would be up to 12 units gonna generate? And then what if they happen at the same time? Because we don't know when all gonna happen, when all the construction is gonna take place. That's something we don't know yet. So there's some things like that we'd like to take into consideration.
I would say, if I may, the planning commission, it's a smart group, of planning commission members, and, they were asking us questions about our comprehensive plan. And if a use is a conditional use, you can really go back directly to the comprehensive plan. If it's site plan review, there's less scrutiny, more scrutiny than an outright use, less scrutiny than a use. So for things like siting, color, anything that would make it compatible with that zone and the adjoining property. But traffic is by far the biggest.
So I mean, I just think of other development that happens out at the end of Tara Road. And there's no talk of limiting that development because that's gonna have more impact and heavy truck traffic on Tara Road. And you know,
What development is that? At the
Any
south
develop-
end of Tower Road?
any development that happens out at RBO Farms.
And luckily, we are working on the interchange area management plan.
But,
And we're
you know.
looking at, that. Yeah,
Citing dairies out there, or expansions or anything like that, you know. Thing else that happens out there. Potatoes and onion sheds have been located out there recently, you know.
If I may, I don't think they're generating 1200 hits a day though. You know,
Yeah, but during harvest, you know, as you know, a truck is 2.2 vehicles.
mhm.
They
It's
equivalent
equivalent.
car trips, so it doesn't take 400 truck trips. It takes, you know, less than 200 truck trips, and there's probably more than 200 truck trips a day going to.
so if I may too, just in preparation for the meeting, I ran just a quick Google search on data centers and conditional use permits. And it is actually kind of a big thing across the country, so it's not a new thing. I would recommend that you guys just go through Google search if you want to, and just check out the different areas across the country that are pursuing that, because it seems that when you're not prepared for a very big influx of one's particular, it could be, you could enter anything besides data centers, but at this point in time, there's a big influx across the country of data centers. And like you said, there's many different types of data centers, so that's general, it's a general search. But you can run that search and find that across the country, many states, counties are changing their zoning to conditional use, just the same reason we are.
But if traffic is a driving thing to make a conditional use permit, then. We should make everything conditional use until we know what the traffic impact is. You know,
We're making a motion to move all.
no, I'm not. I'm just, you know, the logic of that argument, you know, for me, it's. You know, how many trips go in and out of the Port of Morrow's freezer facility?
And,
Oh,
and I
my God.
can't tell you, and if it was permitted in the county today as a prerequisite to that application, we would ask that question.
But it's under site review, it's not a conditional use.
Yeah. And that's another way to capture it. Dan said that it is, another way to capture those impacts. It's just, the bar is just a little bit lower for it.
Yeah,
a site
either way works for me, just so long as I strongly recommend a hearing. It sounds like the hearing route before the planning commission is quicker than the notice and comment process that you have, which is sort of peculiar, but the hearing will solve any potential notice problems and eliminate those adversely affected and aggrieved standing people for appeals down the road. And so you just need a process, and then you need a set of criteria that allow you to get at the adequate public facilities such as transportation. That's all you need. CUP does it. So the site plan process does it. That's what I care about.
And the one data center, planning commission member Killian mentioned, as staff, we bumped to the planning commission because that application had been submitted. Pieces of information had trickled in, and we finally said, if we want a decision quicker, we'll just schedule it to planning commission, and we did. Our code allows the planning director to refer things to the planning commission, so that just enhances transparency. And in that instance, it was a site plan review that were referred to the planning commission. We can do that. That is now what we're calling the type 3 process. Hearing, the process of taxation.
So I just want to add, thank you for your work on the plan. I really do. You know, I do. I know how hard it is. Okay, anybody else, any other applicant wants to speak?
Chair Sykes, we did have 2 additional items submitted to the record, and both of them are represented today, so we should add those for the record. One is a letter dated yesterday, October 2nd. It was dated today. We received it yesterday from Amazon Web Services, and that's in your packet. And another letter we received this morning from the Port of Morrow. I don't see a date on that, and I know that staff from both the port and AWS is in the audience. We didn't address those issues since they're here. I don't know if you've had a chance to review those issues.
I get a question when we're talking about process and maybe, I hope it's all. Excuse me, just a second, no, come on, I'm sorry. I just wanted, before I even got off that, because we're on that topic. When you're going through this process, do you bring up the, the comp plan? Put, say, an actual portion out there for the planning commission to see while they're, I mean, okay, because, I can look on page 8 here, and it says,
Page 8 of,
the comprehensive plan.
With the comment.
page 8 of the conference?
Which
element?
Comp plan, way back
I-
when.
I know, like the very first pages of the comp plan?
Well, let me read it to you.
Okay, I don't have it with me, so.
Yeah, no, but. I just. Anyway, it specifically says that, diversification. Was a. Okay. Industrial diversification. In the 1980 conference plan, concern was outlined that the opportunity for growth and development should become more diversified. While that has taken time, diversification away from an agriculture economic base has been happening. And then it cites electronic data storage. And it says, while diversification has been taking place, it should continue as new opportunities emerge. Now, we've all talked about, we serve the public. And isn't this one way we know what the public wants? Is through the comp plan?
Sure, it is, yeah. I mean, that's the bigger vision and
Sure.
the specific standards, as
Yeah.
you know, are in
Yeah,
the.
how does it work into the decision-making process? Through, say, a process like this right here.
Yeah, that's a very good question. I'll try and maybe Daisy your hand can help. The site plan review standard really makes no reference to the comprehensive plan. the conditional use permit standards has, even though we're looking at the a specific reference, general criteria. And staff would have to write findings, applicant would have to provide them, that says the proposal will be consistent with the comprehensive plan and the objectives of the zoning ordinance and other applicable. Regulations of the county. Site plan review is more refined and specific, and so we don't really even pick up our comp plan to say, I mean, can you imagine if we picked up our comp plan for every application we got? But with a conditional use permit, we would,
Sure.
and a lot of times. We just kind of based on our memory of the comp plan, but when you have a more robust public process with a public hearing, rather than findings in a notice. The planning commission, they always find something that they think we should raise, that maybe we forgot or just adds to the decision. So a conditional use permit would directly bring that in, the site plan review, would not.
What's doesn't the state have guidelines on how often you write your comp plan?
Well, it generally, ours is been acknowledged, so unless we change it,
No, I can't remember. It seems to me that when we wrote ours, they were written in what, after SB 100 back in the
yeah, I think
ancient days.
we were acknowledged January 15th, 1986, and then elements, sections of the plan have been amended, the goal
Is there
9.
a set certain amount of time that they need to do?
So there used to be,
Yeah.
something called periodic review,
Yeah.
and in, about 2003, the legislature said counties and cities no longer have to do periodic review. There's a yin and a yang for that, because when we were required to do periodic review, we had to keep that document pretty current.
Yeah,
And there were also some funds from the state to do that.
right. Cause I'm
And-
thinking, you talk, I'm sorry, I didn't-
And now we're not required to do that. We can. And I think over the years since original acknowledgement, we've updated pieces of it, and it's on our list to do as soon as we get past this part.
yeah, I hear you.
Yeah.
Put a line item
No.
for-
It just seems to me like, okay, if, especially the economic element. Because that's so important, is, we all talk about, we want to serve the public and do,
Mhm.
maybe maybe now is the time to redo the economic part.
Sure.
Because of the huge changes we've had in Morrow County. That way we can sit here and we can say, well, we're representing the public, but it went through a process of saying, rather than just hearsay or our small group or whatever, this would give us, because being planners, I know you guys like to look back and see, really, findings of fact and everything,
Yeah.
you don't like subjective stuff. I mean, it goes contrary to what you do. So I don't know, maybe, our economy is so different than 2014,
Sure.
that when we wrote this, that you maybe it's time. And that we can all sit there and go, okay, and agree on, data centers and windmills and solar farms and all this stuff.
Actually,
There's not much to do.
speaking of planners, that's really music to our ears. Maybe your decision is before we bump it to a conditional use, go back and take a bigger holistic look at the plan. I'm not being contrary at all to what the planning commission recommended, because if you had listened to that hearing, there is a big sense of urgency amongst the planning commission and the community about the impacts of data centers. So it was not reactionary.
Okay.
But I think to be more holistic, we could also look at our comp plan.
And that's why, I listened to the hearing, and that's why I said that. It's because it's, you listen and you go, this seems like, just a more solid way to go about it. There's changes and people concerned with them, and let's have the input the way it's supposed to be. Let's, because the state of Oregon did this for a reason, and they set up, everybody has to have their comp plans, So, and rather than having piecemeal, take a shot here, take a shot there, just group like this, group like that, so, like I said, when we were doing it, we had ag come in, we had industry, we had citizen night, when citizens came in, we listened before this thing was formulated. So that's just, doesn't help us right now.
I appreciate that, because I will say, that we can see the wins of Morrow County. things can get a little bit controversial and hostile, but to see Morrow County as a growing county, as a industrial, as an economically successful county. Unfortunately, many counties our size in rural Oregon, their largest employer is the hospital, and that's tragic. And I think to be able to have the economic success we've had is a testament to the success of the county. And I think being able to come from that position and say, where are we growing? What's the plan here? That you're absolutely right. I think updating our economic element would be a very timely.
And I absolutely understand the people who are worried and concerned about what's, how it's going. You want to have control. You don't want to feel like it's out of control. So I understand what you're saying. I just think it should be done. It's planned out,
Comprehensive.
Comprehensive. What about that, guys?
One of the objectives I would like to see achieved through this process is some statement, and you can put it in the code, that data centers are an allowed use in whatever zone you want to allow them, just so there isn't any question, because you're right, 2014 data centers really weren't a thing and hadn't been invented. And so making it very clear so that there isn't a question, well, gee, someone couldn't say we have too many. I'd like to deny this one. No, it's an allowed use. We're here to talk about conditions that mitigate its impacts, period.
But yeah, that's unbelievable.
Well, they're meant to be there. They're not there with.
Good.
Amazon, Bezos hadn't even gotten into his garage yet at that time. Okay.
Started in 2000. Just.
Oh, he did.
And
I don't think
data.
Oh, yeah.
Data.
Oh, okay, well.
Good.
I know, because I know we talked about it when we did the comp plan, because it's in here, and I remember talking about it, but we didn't envision the scale, but,
That's right.
so. Anyway, okay.
That time we didn't really work.
Okay, sorry, sir. Go ahead.
Alright, I'm Dave Nominero. I represent Amazon Web Services here today. Just want to introduce myself really quickly. I've known several members of that, or several of the people present, but worked for Amazon for about 6 years. Prior to that, in a different life, I was in the Army for 9 years. It's actually brought me up to Washington. There's a pretty large Army base just south of Seattle that I was stationed at for a few years. I currently live in Morrow, Washington. My wife grew up there, and so we started to develop family and stuff. But let's go live near the family and move out here. So I live out here. I'm also from a very small town. Shouldn't say the state, but I'm going to. I'm from a small town in California. It faces similar pressures to the rural counties that do in Eastern Oregon. It's a town that's 30% smaller now. 20 years after I left it, was when I was there, it's just going to do a lack of opportunity. The lack of opportunity there. But I think that's enough about me. I'm gonna just give it a little refresh on Amazon. So we are we've been one of the speakers for a while now. We've invested capital investments and operating investments, $18 billion into this region. I mean, that includes Morrow and Umatilla County. Morrow County specifically, we paid $33 million of taxes in 2023 alone. And that makes us the largest taxpayer in the county, and in fact larger than the next 19 taxpayers combined. We're established, we're part of this community, and beyond just kind of an economic impact, we do see ourselves as members of the community. We support childhood education programs in the county. We support sustainability initiatives like tree donations, last Arbor Day. We support senior programs and food pantries in the county. And we've given $100,000 in scholarships to the Blue Mountain Community College for students pursuing careers in data centers. And by the way, there's no strings attached to those scholarships. They don't have to work for Amazon afterwards. They can go pursue a career in data centers with whatever data center they'd like to go to. But we do see ourselves as members of the community, both economically and giving back to the community. So there's been a lot of talk about like how we got here. And I think I agree with everything that's been said so far. Just to sum it up though, we started in October of 2023. I wasn't at that planning commission meeting, so I'm not exactly sure what went down. I've read the minutes, but you know, we did get a call saying, hey, we're looking at data centers. Invite your inputs. We spent a lot of time in November kind of talking about how we would do things, and in December, the planning commission actually voted on the package or recommendation for how to view data centers in the zoning ordinance, and voted to bring that to you. It did not include conditional use. It was just kind of what we're now calling the site plan review, those specific to data centers. Back in January, I sat before this board and I asked, actually, and joined with the staff, and we asked, we think we can do better than what we got in December. Can we have more time? And then you said, yes, we'll see you in March. We met several times in the intervening 2 months between January and March, came back in March, well, I think still need more time. This is a big deal. And it really is a big deal. I think what Daisy's done here, I mean, this packet kind of speaks to it, this multi-100-page packet. This is a land large update to the code, and I think it really makes the code robust. It really protects those land use decisions in the way that Dan Kearns mentioned, you know, here we are today to kind of talk about that. Now, after March, we had 3 more planning commission meetings, so that makes it four total. And it wasn't until the last half an hour of the last planning commission meeting on August 27th where conditional use was reintroduced. It was not talked about in any of our working sessions after you know, November. It was not talked about in any of the planning commission sessions. I attended May, I attended July, and I also attended August, and that was the end it was talked about. And we had at least half a dozen multi-party, you know, multiple developers report the staff with those kind of sessions to discuss this. And conditional use was never discussed. It was always talked about as you know, data centers would be along with any other industrial development, just go through this called the site plan review process. You know, the planning commission on August 27th voted 2 things. They voted adopt this thing, this draft that everyone had worked on for 10 months, and then also let's debate really quick and let's add just receive data center, strike that out and put those in conditional use. So what I'm asking you today is to basically help set the policy for the county, help clarify the policy for the county, and do it through 3 kind of specific asks. And I outlined this in detail in the letter from Amazon for you. But the 3 things are adopt this consensus draft that we have for the county, or that we have that Daisy presented, reject conditional use for data centers. And then we have a couple small changes that we think would really address some of the issues that were brought up and were prevalent in today's discussion. So I just want to spend a second to go a little bit more into those 3 things. So this, what I call the consensus agreement, is exactly what you have before you, except data centers were still a use allowed outright. Those did do the things that we sought to do at the beginning, which is make the code robust, modernize the code, bring the code into compliance with state law, and address the concerns of the community. So we split off previously in the previous code, data centers were a ministerial process. We elevated those to administrative process, which as Daisy went through as a very long public notice, public comment opportunity period, and an appeal period. So we elevated all industrial uses, including data centers, to go through that. We made robust standards around water use and and waste and water disposal, and ensure that both of those things are in compliance with state law, and the state agencies responsible to review those do have the opportunity to review those prior to occupancy. And we did discuss, and we do have, since traffic was a major concern here, we do have a traffic analysis that's required, and mitigations that are required for if mitigations are found to be needed. Like Dan pointed out, so far in this county, mitigations have never been found to be needed once. But we still have in the code today a construct for not an applicant saying, here's what I think my things are, but a study supported by an industry standard for reviewing traffic, and then the obligation to mitigate those traffic are in this consensus draft. So we don't need conditional use to make sure that traffic considerations are met. That is in the consensus draft before you today. Now, because so I think I cover why we should adopt, why I'm asking you to adopt the consensus draft and why we don't need conditional use. I do say we do have a couple small changes we'd like you to consider. One of them being traffic. Now, we have a robust way to look at an individual traffic or individual developments traffic impact. In fact, at the last planning commission meeting, when an Amazon data center development was reviewed by the planning commission, but the Department of Public Works Director Eric Ives came up and spoke to the fact that he has zero concerns with the traffic that will be generated by that site. Why was he able to say that? Because we had a traffic study again done by industry standards that kind of chance to review that, and the planning staff have a chance. And the planning staff's or the planning department's consultant have a chance to review that. But again, that's only a single development at a time that can be looked at. Now, Oregon state law provides for what you can call a development agreement, or basically it gives someone like the board the authority to negotiate a multi-development agreement with regard to something like traffic, or just with regard to how a developer might want to build multiple things in phases over a period of time. And we think that this is a great way to look at traffic more comprehensively in this county. Now, I say that's a tool available to you today, but the Morrow County zoning ordinance both today and the consensus draft doesn't really have a framework to give all the interested parties, the applicant, the planning staff, public works, and a way to like really be on the same page about how to do such a thing. And so what we're suggesting is we've made some suggestions in the code in that letter that's in the record that would give that framework. And we're saying, if the county does have concerns about comprehensive traffic impacts, development after development, we'll implement these things and then we have a tool to address them. That being said, we did review these or versions of these and did ask for prior versions. I don't think that exact version, but we did ask for prior versions of this with staff during this nearly year-long period. We're never really able to come eye to eye with staff. Staff had concerns that weren't addressed in our verbiage. And look, this is such a big thing that we're doing here. It just honestly kind of fell by the wayside of like how to deal with traffic. And we got to August 27th. We hadn't yet met eye to eye. We decided to open forward this consensus draft. So even though you do have a robust way of moving traffic before you in the consensus draft today, I think that the county or the board can provide a policy decision that we are interested in this, acknowledge that not all the questions have been answered, and just give guidance to the county to go review or make consideration, review options for how we could do these kind of comprehensive traffic mitigations. And then return to the board in a couple months' time with a recommendation on that specific matter. Again, you still have, still be able to adopt what's in the consensus draft today. We have a great new code to work with that's has some of the most stringent requirements for data centers and industrial development in general. That's ever been in Morrow County's code. And you give the signal saying we can still do better. Let's keep trying to do better. So that's what we're asking you today. One more thing we're asking you is we heard about citing today, citing data centers. We want they should be or the public through the planning commission thinks that they should be in places where they have minimal impact. We have identified sources of industrial land in this county, land that's industrial today, that can be opened to data center use. What is that? That's the space age industrial land that's in the western half of the county. That's far away from residences, commercial uses in other parts, and is kind of almost firewall from the county through by the Navy bombing range. And so we're requesting that the board consider data centers be added to the space age industrial list of outright usage. And we think that a way to do that without having a big 14,000 acre policy would be to just do that for an initial 320 acres that's immediately adjacent of space age industrial, that's immediately adjacent to the airport. It's surrounded on two sides by industrial land, both general industrial, airport industrial, and the other side by non-farmable EFU. So EFU land that's never been farmed, has no history of farming. It's not currently farmed. It's not considered farmable. And so we think that again, this is a great site because it's away from other parts of the county where people don't care about having a data center next to them, and opens, and it is a policy decision that the board can make to say, yes, we are open to more data center development, and we're open to it in this area where we think this very small 300 acre area where we think it's unobtrusive and is already zoned industrial. So I went through a lot in this, and I kept it kind of high level. So I do want to have our Amazon's counsel, Megan Lynch, she's spoken in front of, I think, with this board before. She definitely spoke for the planning commission before, but just get a little bit more detail how we might accomplish that. But just to sum it up, I think we should the policy. I'm asking the board to make a policy decision to adopt the consensus draft, reject conditional use. So in other words, keep data centers exactly like any other industrial use, with a reminder that this new consensus, again, is the most stringent set of criteria the county has ever had for industrial users, and to ask the staff to review how the county can more effectively mitigate a comprehensive view of traffic, and how the county can open up space age industrial land to a small piece of space age industrial land to data center. That's all. Do you have any questions, Chair?
Okay, so we all both the planning and AWS, are you in agreement that the traffic is a lightning rod on this here? Is that what's hanging this all up? I mean, we spent a year together talking.
I think what we have, Commissioner, or excuse me, Chair, the code has a robust way for applicants to demonstrate their forecasted traffic impact, and it gives robust tools to the staff to compel that applicant to mitigate their impacts as part of the development.
Has the planning commission told you that that won't do what you're saying it's gonna do? Have they said that to you?
I have not heard. Um,
Okay.
I have not heard from the staff that they do not.
Oh, yeah, I'm just trying to find out where you guys are. You know, where's plugged up at? Where the agreement is plugged up. I understand, see, you know, if you throw out number two, you know. I think that's pretty good on the agreement. Okay.
Well, I think we could probably speak a little more to the traffic piece, and there's a lot of nuance to it. That I think would maybe best be handled in a work session or another forum. And then the SAI thing is, to be honest, a little out of left field. Sort of, to us, feels like a parcel rezone proposal that would need to have neighboring property owner approval and potentially goal exceptions. There's a lot more there that I don't think, and we hadn't heard about that until like yesterday. So that was maybe, I would say, a little out of left field, and we feel really, not consistent with prior conversations, but the traffic piece, I think, could be fleshed out in a work session or in another forum, in a way that I think, and we're both in agreement that the current system to like mitigate traffic impacts doesn't necessarily work exactly the way that we'd like it to for these types of like campus developments. But that said, we had a lot more divergence that I feel like we have very much had a lot of conversations to come together and mitigate some of our concerns and create a draft that I think to some degree satisfies both people and
I would just add, let's give a specific example. The way the regulatory process works for development, not just in Oregon, but any place. You have a development, you evaluate impacts of that development, and you mitigate that proportionate share. What they're suggesting, and I've also heard it from the court, is prudent, actually, rather than piecemeal intersection improvements. Let's build a nice intersection improvement, but the system doesn't work that way. I think we can get there, but asking for the board and the public works director, cutting out a planning commission and other process isn't the way to get there. So Daisy's suggestion to take that piece to a work session, I think is a great idea. And we've been working with them. We've one intersection in particular, we know there's a couple more data campuses coming, but there's also other development on the horizon on vacant land. So do you design a project and assign a proportionate share to AWS, for example, and then latecomers would reimburse? It gets really complicated really fast, and honestly, our very rural code isn't where it could be. I really like the idea is the message, but I think this language here, again, that doesn't anticipate a formal review process doesn't work ideally. It's also why I know Commissioner Winholt asked a few months ago, why does planning need an engineer? Because every time we see a traffic study, it says the existing capacity is fine. We don't need to mitigate. So then we come back and say there is some mitigation that would be ideal, and then we negotiate back and forth. And I don't think I'm exaggerating. And if I might, can I ask Dan Kern to opine about this kind of pre-designed traffic mitigation piece?
He was the next one I want.
Okay, perfect, thank you.
It's a good idea. It could work. And it certainly would streamline that whole discussion about mitigating conditions, because our perception is these data centers, first there was one and then there were several, and the future looks like there are going to be a lot. So that kind of development agreement, and it's governed by statute, chapter 194, and it should have a public hearing associated with it, and it should also have a reopener clause so that if traffic volumes and conditions turn out to be different, down the road, years down the road than anticipated, it can be reopened and different mitigation can be fashioned to mitigate the impacts from these developments. But uh, it would certainly streamline a bunch of applications that we see queued up for the pipeline to come through. This is really the real heavy lift issue for these, as far as the county as a regulator is concerned.
Wouldn't it also save a lot of money in rebuilding roads 4 times, 5 times over?
Sure.
Right, so, I mean, I think this is a look at the plan if we can get there.
Right.
But I would just see it done right and built for the future and not done at what the assessment is for the one campus. If you know there's gonna be 4 campuses, you should be looking at doing it for 4 campuses plus, because we know this other stuff. And if we
Right.
do it all at the beginning, it's gonna save a lot of money and a lot of headache.
Do you,
When-
just a further question, Chair, Dan, do you think we could move forward with this concept of a development agreement without amending our code?
I think you could, although AWS has proposed language for as part of this amendment package, and it looks sufficient. The only thing I would add is it's in their proposed section 5.020 F7 that and E9 that it reference pursuant to a public hearing as prescribed by ORS 94.508. So that would be sufficient. And you're right, the incremental nature of these things was a problem for ODOT. So initially it appeared that, okay, 1 or 2 or 3 data centers would warrant the construction of I think it was a right turn refuge lane. And ODOT said, no, why don't we just change the shift change outside of the PM peak? We can skip that turn lane and just wait until enough of these things come along that would warrant a full rebuild of the intersection. So, I mean, what you're thinking about this is the way ODOT looks at it. And understand too that this would all be reviewed by professional traffic engineers, and the county has traditionally relied on ODOT because it's ODOT facilities that are most significantly impacted. But I think the county does have a contract with a qualified traffic engineer to review these things and help, fashion mitigation that will do the trick.
And Chair, we'd be fine with that pursuant to public hearing. In fact, if you read the narrative, just above the code, we say, we do think this requires public hearing. So we kind of anticipate that this gives the public would have an opportunity to comment on this development agreement prior to it being executed, just like any business that you review.
Actually, for the record, Dan Kearns and I reviewed about 6 versions of the development agreement. But we tried to get there and we didn't. So we ended up approving one of the campuses in the Port Industrial Park with a shift change. I don't know if we've issued the final zoning permit on that first. Anyway, we've tried the development agreement. It'll be plenty of work for all of us, but I think it's a great tool. So moving forward with that, with the right process that Dan's recommending, as staff would be very supportive of that. Chair, I have one additional comment, if I may. This is not the time to rezone an individual piece of property. We didn't provide notice for that. We haven't written findings to rezone a specific piece of property. Dan can speak to that. We talked to him about that to some extent Monday when he was driving through. This is not the time to do that part.
Chair, I think we are prepared to address that. And I say we because I'd love to, if you don't have any further questions for me or that the board doesn't, I'd love to tap in our council, Megan William, can kind of explain how we could accomplish that.
Is that all right with you guys? You want to?
Further questions for me?
Well, not really part of it.
We can listen.
Sure.
We're not commit to making a decision on it, but we can ask.
All right, well, thank you very much for the opportunity board to speak and staff for bringing this home to the right this last year.
We betcha.
My name is Megan Lynn, and I'm an attorney for Amazon. And you all have already discussed everything that I plan to address. So I think just starting with, I think the space age industrial, what wanted to talk about. So I think I think you've heard some of the context. AWS, obviously, you know, is a developer of data centers in this county. And in the course of seeking out developable sites, we looked at the SAI zone because it's already zoned industrial. For a goal exception that was adopted in 1987 for Bowen, but it was never industrially developed as contemplated. And today, much of it is actually just farmed and or undeveloped. And there's no intent to touch that farmland. Instead, when looking at it, we know that AWS noticed that there was one site west of the Boardman Airport that is not farmed. It's amenable to industrial development for a lot of the reasons David noted. It's only 2% of the overall 14,000 acres of SAI land. It's already close to the freeway. There's no nearby residences or incompatible uses. And our proposal, I think, isn't accurately stated in the letter. I think the text amendment could be a little more constrained to say something like data centers west of the airport within 1.5 miles of I-84 or Highway 84. And that would be the only site. In terms of how to get this done, we could do it through a rezone or a text amendment. We're quite frankly raising it in this form because you are amending the text of the code. That's why we're raising it. But if the board felt like it needed additional information and we would take that back and work with the county and planning staff.
All right, you have any questions? Oh, we can't. It's just listening.
Oh.
There's just all listening.
I'm looking at questions that don't know.
I'll also just, because traffic has come up a lot, I just want to read the criteria. First of all, removing data centers to conditional use, this really does wipe away a lot of the work that went into drafting the site plan review criteria. And that site plan review criteria, a big piece of it was to address traffic concerns. So I kind of wanted to read what is actually in, and this I think is on page 184 of the package. This is the review criteria to address traffic in the site plan review criteria. The transportation system must provide for safe, orderly, and efficient circulation of traffic into and out of the proposed development, and negative impacts to the transportation system are mitigated adequately to achieve consistency with adopted county standards. County transportation facilities shall be located, design, and construction in accordance with the design and access standards of the TSP. And as conditions of approval, the planning director may require an applicant to provide traffic mitigation or a fee in lieu of mitigation as identified or supported by the TIA and or the TSP. Mitigation shall be required to address level of service failures or safety concerns, must be proportionate to the anticipated traffic impact from the proposed development being reviewed, and it goes on. And I guess my point is that all of this is in site plan review criteria, and it is not in the CUP criteria because all of the effort has been been to draft criteria in the site plan review section, which is 5.020, in order to address real problems concerns that came up throughout this year-long process. We'll just leave it at that because I know traffic is just not a lot.
That doesn't change what David.
Right, doesn't change
Okay.
anything.
All right,
Doesn't
that's not
change
sure how that,
Yeah.
does that have anything to, okay, it's just a comment on what
Right.
they kind of already worked out.
Right,
Okay.
exactly.
Okay.
So with that, we request reject CUP and we reject making data centers a conditional use, adopt a consensus draft with the changes requested. With respect to the development agreement.
Thank you.
Chair, I don't know if anybody on Zoom wants to, or if anybody else.
That's true, we haven't
We got coming.
forward.
He-
Is there anybody else?
He's good.
Oh, okay,
Right.
good. Keep listening.
Is there anybody? Okay, that would be application, no, that we pretty much covered everybody. And then just neutral people, I guess. Invite interested parties and agencies, that's kind of, is anybody just kind of neutral, wants to make a statement?
No one has any.
Yeah, great.
Who's on it? Oh, we got quite a few.
Got 10.
Okay, if you would like to make a comment, on Zoom, just raise your hand, please.
How many people are sitting there at this?
You don't see anybody, I guess, do you, Tamara?
I don't.
Okay. Valerie, you see anybody raising your hands raised?
No hands raised.
Okay. I think we'll close.
Sorry, before you do, close the hearing, do you mind if I speak to this, or one of us speak to the SAI thing?
If you speak to what?
The spacing industrial request by Amazon, I don't know. That
I did mention something, but I'd like for Dan, I mean, I think I covered SAI. I don't know how we rezone an individual piece of property without going through a quasi judicial hearing. And I don't know how we amend the SAI zone without findings and without vetting it. And we have started to peek into that. I actually raised the issue that it could be an opportunity, so did the state. But we have a lot of questions about it, and that's unresolved. I would recommend not adopting that as part of this, but I think Dan could offer you even more legal reason
Okay,
why.
yeah, okay, and of course, we're considering the whole package you brought to us, not just, okay, so
That's
yeah,
right,
yeah,
for
go
sure.
right ahead, anybody, if you want to address, or Dan.
It's just like that.
Even though a zone change would be done by finalized by you, the legislative body of the county, this would be a quasi judicial zone change. It'd be specific piece of property, specific applicant, specific request. So it'd have to go through a quasi judicial zone change. And my understanding is that there is a goal 3 exception for the SAI zone, but it's specific to these space age industrial uses. And so it would, to rezone anything in the SAI zone would require at least a goal 3 exception that's specific to whatever that use would be. So it wouldn't be a simple thing, and you could not do a quasi judicial zone change in the context of this text amendment. It's a good idea, but they should apply for it.
Yeah, not that I'm gonna advocate at all for making that requested change today. But I didn't understand as being a zone change is adding an allowed use in that zone. So if it's adding an allowed use, you have to do a goal 3.
So
So,
we
yeah,
actually,
the goal 3 exception, it's super specific. And as I understand it, and anticipated that this would be like a little Cape Canaveral type thing in Morrow County. And so it's very specific to like space exploration and rocket launching and space age uses, and this was put in before the internet was adopted, I think. And so it's surprisingly specific, and that's how goal exceptions are. They're very specific use that would justify an exception to the goals. And so I don't think a data center qualifies as a space age use, and to amend the list of uses allowed in the SAI zone would require an amendment of that goal exception. Yeah, it's bizarrely specific in this case.
so in summary, in my own words, it sounds to me like you're addressing the request of the court, which was to not make it, to put data centers as a conditional use. But to otherwise adopt the draft with the amended language that Dan just shared, that would allow, a process for a development agreement. Did I miss anything?
That would work.
Okay. Any other comments on, if you want to support the record? Because once it goes out there.
It's been a challenging but good process. I've learned a lot. I thought I knew a lot about this process, learned a lot. So I think as we're not required to collaborate when we amend our code. It just makes for a better process. And we'll continue to do that as we move forward with code or plan amendments for sure. Not sure when we're gonna schedule in that chapter 14, but we'll get it on our list.
Now. Tamara, when, if I close the public testimony portion, you know, and then we can still talk to you and report it. Is that considered on the record if there's an appeal or something like that? The discussion after the public hearing? You know,
It's still on the record.
it's part of the record.
Yeah, we just wouldn't want to introduce any new information.
Correct, okay. So, is there anybody else on Zoom or in the room before I close the public testimony portion? Okay, I'm gonna close the public testimony and then, we will, the commissioners will deliberate and ask questions of staff. Or, okay? If you guys wanna.
So I guess I'll make comments that, I appreciate what Dan mentioned today about why the, site plan review was really important, because all of it, I had questions of, you know, you have this term I've heard before is a sophisticated developer or investor. And, you know, kind of getting fire everywhere as far as getting the water and sewer and those other things, but the fact that it opens the county and the developer up to potential appeals up to possibly 10 years. I understand and I agree with that, and I'm all on board with that now. But when I look through the, one of the changes here that really struck me. And, you know, I was going through each section and I realized that it's in each section that you have to have a zoning permit to do an outright use. In EFU, number one, it says farm use. So, and when I read the zoning permit, it says like a change of use. So if I had grazing ground that now somehow I was able to put water rights on it, and I'm gonna make it center pivoted irrigation, I've really changed the nature of my farming. So I'd have to go get a zoning permit.
It's still the same, it's a farm use, regardless of which farm use it is. So unless you're putting in a structure or changing the use. So if you're changing it from a farm use to a different allowed use, then it's over here.
It is confusing at best, and I've done this for some years. You wouldn't need a zoning permit for a farm use unless you're building a structure, then you would need a zoning. And we can add some clarification, and it's a fairly universal place to put that and to treat it in a code. And we're not changing that, that's been that way.
So I'll make it, you know, a personal example. Is that
Okay.
my parents' property, EFU, there's 13 acres there. You know, or it's not EFU, excuse me, it's rural residential. Farming's allowed. There's never been any farming on it. I want to start farming part of that. Now I have to come get a zoning permit?
No.
But the way I read it, it says, you know, because I haven't done that before. So it's a change in use,
Yeah, we never have, and I don't know.
but if the way I strictly read it, and I can sure be wrong.
The literal
It's
way
not-
to read it is, you're correct.
So I guess my thought would be is that a zoning permit isn't needed to do an outright use. Because really the zoning permit comes into play if you're gonna build a structure on it. To get that building permit, then you have to have a zoning.
I think farming is a little bit tricky, but the idea of a change of use would be if you have a zone where you have, the residential use is obviously allowed, but also say limited commercial, a church is also allowed. If you wanted to convert your house into a church, that would be a change of use, even though you're not putting in a new structure. That's how we think of like change of use, and it gets a little bit murky, but, if that answers your question.
But if you're gonna put in church, you're gonna be building buildings, so you're gonna have to have a zoning permit to build the
Well,
church.
but if you were gonna convert a church to an allowed residential structure in a residential zone, both uses are allowed, church, home, but you wanted to turn your manufactured home into a church. You could totally do that, but you would just have to come in and get a zoning permit because you're changing the use. And that's just so that we could review impacts such as traffic, right? Things like that, wouldn't necessarily, it's not really a residential use anymore, it's a change of use. So we wanna look at the impacts of the new use.
And also in under the zoning permit definition, it also cross-references section 5.010. So if it's not a structure or a change of a structure, you would not need, it's outright without a permit. So it has to be read in the context.
In the forest use, it says harvesting. You know, so I can grow trees now, and start harvesting. Is
No, that's what I'm saying. If you're not erecting a structure that's over 100 square feet, you would not need a zoning.
it's not there.
It's
Maybe
not.
it's just me.
No, it's not just you. But I don't know what to do with it. It's, in that part, we're not changing. So if, maybe it's our next project to make it more clear.
Well, could we just, because we start out with uses permitted outright. In each section, we say zoning permit approval in accordance with the law is needed. So why not just strike that from each one? Because nobody get a building permit yet, is it?
Well, but do you see the new red, for example, under forest use? It says zoning permit approval in accordance with section 5.010. And 5.020. So if they're not, that's where I'm extrapolating, so if they're not. If they're not building a structure, they don't need a zoning permit. And I suppose we could say forest operations or forest practices. We could move number 1, or we could say would not require a permit. I mean, it would almost be redundant though, because I think Daisy has outlined it well in the red part. So just going out and grazing or harvesting timber would not require a zoning permit unless you're also building a structure. That's over 100 square feet.
Yes, again, my thought would be just strike the zoning permit from under our regular uses. And when they come to get a building permit, they have to get a zoning.
That would require some major changes to what we just did.
I think that our reasoning to for putting it in there is because if you are changing a use that has additional impacts that we do need to review via zoning permit, we've had confusion with people saying, why do I need a zone? It doesn't say I need a zoning permit. And this is just our way of clarifying that. But if you have language that we can put in there to make it more clear, we can do that. But more intensive uses do require the zoning permit review if, if you're changing the use. And so I feel like that's more clear than it was before.
So again, this is the part that you're referencing, the confusing part, we haven't made any changes to that.
Well, we added the zoning permit under our regular uses. Zoning permit approval.
Yeah, and reference the 5.010, and again, 010 and 020 is if it includes the structure.
So on page 17, under Article 1, this is how it currently reads, is that prior to the construction, reconstruction, alteration, or change of use of any structure larger than 100 square feet or use for which a zoning permit is required, a zoning permit for such construction, reconstruction, alteration, or change of use or uses shall be obtained from the planning director or authorized agent. The zoning permit shall become void, and then it goes into the expiration requirement.
So there it all references a structure.
No, but it also says to change the use of a structure.
Of a structure,
Of a structure,
So
not of the use of the property.
correct. Like people move dirt, like we get calls, who's moving, hundreds of yards of dirt, we don't regulate that. They put up a structure, we do.
and that's how it reads in 5.010.
Exactly. Maybe just me. The same as confusing.
Okay, any other questions, Marty, any other questions with staff? Any more, Jeff?
No, I just, well, so, I'm in. Forest use, I guess, uses to conserve soil, water, and water quality and to provide wildlife and fisheries resources, you'd have to get a zone. Just our farmers.
So the way I'm interpreting that is only if it includes a structure.
So. Right. Good. Again, and it's maybe just me, when I read it, and it's outright, and it says a zoning permit.
So another example too is like
Is it-
events, like special events and the abuse zone, those would still require a zoning permit. Again, so we can look at impacts, we can look at traffic. And a zoning permit is very simple. You come in, we sign usually that day or the next day. If it's an allowed use, it doesn't have any notable impacts, there's no complexity to it. It's a very straightforward process. And I think that's where we want to be clear too, that it's our opportunity to have input into the uses of land and to speak to basically be able to review what's going on. So even if you might say, oh yeah, there are these one-off cases where it seems crazy that they would need any permit at all, it is a very simple process, and they would likely come in and we just tell them a zoning permit is not required intuitively. But even if a future planner did say, yeah, zoning permit is required, it's a very simple, it's a ministerial process. There's no notice, there's no hearing, there's no subjectivity. And it's even Tamara doesn't even review them. It's just the planner signs off on it over the counter. And again, we do get complex zoning permits as a range, but for those very simple, like a change of use of a structure or the construction of a structure that's allowed outright or a special event permit, those things can be reviewed very, very easily. And I think that it makes sense that the default being a zoning permit isn't restrictive.
So, no, I guess the other aspect of it, and like we said, a lot to say about, representing the people of the county. I look at the voting, the way the people vote in this county and their thoughts. It seems like it's more government regulation and overreach. To get a zoning permit to do something on my property that's an operating use, that it's not involved a structure.
How about if we did, I hear what you're saying, and I think it's a real mechanical piece that we need to do, because I think we're on the same page. If we, between now and the second hearing that you have for this, made a note in the forest zone and the farm zone. Now I have to also look at, the residential zones. I don't think it's in the residential zone. We could even put a parentheses that, a zoning permit's not required unless a structure. We could add some language to that. I think it does it with this language, but it isn't as abundantly clear.
But to be clear, there are some situations where a new structure is not, a zoning permit is still appropriate.
Like a mass gathering, or something like that. But
That would be probably subject to site plan review or something.
But yeah, not.
You're going to address, because it'd be subjective, but a mass gathering, are they going to have, if they're serving alcohols or other things, if it's for sale, there's certain requirements if, traffic impacts, all these different things.
an outdoor gathering is actually an administrative review in the forest use zone.
Didn't we do one of those for a wedding? Not that long ago. Yeah.
If I, your sense is correct that uses that are outright allowed on EFU land are outright allowed. State law says that local governments cannot impose any additional conditions or criteria on those uses. But as I understand the way the zone permit works in this case, it's just a process where the county verifies that what you're proposing is something that's allowed outright. I don't see it as really a discretionary review or an opportunity to impose conditions or anything like that. It became a big issue when cannabis was allowed in the state, and a lot of counties pushed back and say, wait a second, I'm not going to allow conversion of this, wheat field to cannabis. And so they had to go in and amend the code, the statute, and say cannabis production is a farm use, and that made it clear it's a subsection 1 use allowed outright. So your sense is correct. If it's an outright allowed EFU use, the county cannot impose any additional conditions.
And we wouldn't even permit it, but I think what Commissioner Windholz is saying, it would read more clearly if it said, you don't need a permit to farm your land. And I think the
Yeah.
way, the plain reading of it, it's not very clear. All I can say is it's been that way for a long time. And it's more or less universal in Oregon, and we could change something. And on the record, that's not the intent. You're farming your ground. If you're not building a structure, we don't, it's allowed truly outright without a zoning permit.
And anybody who came into the planning office and asked for a zoning permit to farm would get laughed out of the room, to be honest, but I think that's like, that is, I think clear, that's intuitive. I don't necessarily think that we need language that clarifies that, but in this case, there are certain things that are allowed outright that would still require some level of review and, or just that we don't know, that it could require some level of review. There's a range, right? It could be a very minor use, it could be a very, a more intensive use. And I think, that having that in there doesn't restrict what people are doing.
And it might be a simple fix. So in the farm and forest zone, under section A, the purpose, before section B, just move those first categories under the purpose and just be explicit that forest use, including these things, do not require a permit. The other thing is this is, in the EFU zone is explicitly listed in ORS 215, 283 sub 1 as an outright use. And I don't remember what ORS 215 the forest zone is in. But it's listed as ORS 215, 283 sub 1 as an outright use, not a use permitted as a land use decision. So I'm sharing that because the way we have it treated here is consistent with the state statute. It's not perfect. That's why the lawyers make the big bucks, you know, because then they come in and say, oh no, you don't need, they can't give you, require a permit.
I could
And
do a
farming-
large memo about this if you want.
Oh,
Yeah, sure.
that's a good path forward. What the intent is. Would
It
that-
sounds like a master's thesis to me, but
Maybe. Would that be satisfactory
Yeah,
to do a memo? Okay.
Anything else on your list there?
The most answers anyone can ever get is because we've always done it that way, but that's kind of what I'm saying. But it is also that way in the state law.
Precedent is a powerful thing.
It sure is, for sure, yeah.
Okay, any other questions, Dad? Okay, Dan, what's our procedure here? Hold it open? Is that what we do? What do we do?
you could, yeah, if I think that there are a number of tweaks that you want to this text, plus AWS has suggested others that you want to include. So I think that it'd be appropriate for staff to fold those changes in and bring them back to you. Because this was a pretty thorough discussion of what you wanted to see, and you know probed a lot of these issues. And I think Tamara and Daisy, you have a pretty clear idea of how to wamp up a written version of what you've heard today.
Yeah, and I will just repeat those so that we know, and we have another hearing scheduled for 2 weeks, which it's. Justin doesn't know how to explain it, and I sure can't, that because we're not home rule, we have to have a second reading of any ordinance. So if we have that second reading, would we have to have another land use hearing and then a second reading of the ordinance? Because I really think the only changes we're looking for is we agree, and the board can correct me if I'm wrong, they agree to the changes minus moving a data center to a conditional use, and also including the language in the AWS letter, on page 3 of their letter, amending 5.020 F7 and E9, which would provide for traffic mitigation with additional language that would read, subject to a public hearing as prescribed in ORS 94-508.
Okay,
was
so
it-
you could,
So,
if that clarifies what you want to do, you could do a first reading tonight, make a motion to approve with those changes, and and then when it comes back for second reading, you can see what it actually looks like.
Okay,
There wouldn't be any public testimony at the second reading, is there?
Not unless you want it.
Right,
You
okay,
you could do that, but that wouldn't be standard.
right, okay. All right, so, I guess I'll entertain a motion to do that.
Well, do we need a motion or is it just,
I think
Yeah.
Dan is suggesting
Simply do
you
it.
do.
Yeah, a
have
motion to adopt and do a first reading with those changes.
would make the motion to adopt it with the changes to move the data centers back into, outright allowed use and to, have the language as adjusted in regards to NCCO 5.02 E2 and 5.020 F7 and 5.020 E9. As
Okay.
presented in the AWS.
We clarified that it would be an administrative review, not like allowed outreach. There's two categories of allowed outreach.
Right, it'd be subject to site plan review.
Did you hear that, Dan?
Yeah, I would like a land use process associated with data centers. That in my recommendation is push it into a planning commission hearing. That's quickest, clearest. The game would change a bit if you had a development agreement already in place addressing all the traffic impacts. So,
Did
yeah,
Jeff's motion address the way you should think it should be done?
to make it an administrative review, and that has the option of the planning commission hearing that, right, Tamara?
Yes.
Yeah.
But under site plan review, that is administrative. Unless we bump it up to a public hearing with the planning commission. So
Right.
site plan review for data centers with administrative review. Site plan review is administrative.
Okay. And as I recall, the site plan criteria, they get at adequate public facilities. Right. Okay.
Yeah.
Is there a second?
Do we have the motion we want? Right?
Yeah.
Okay.
Valerie,
I think so.
I think so. I've got it there in the recording. I can go back and listen.
As long as Dan, says yes, then we've got it, right?
I'll say.
Yeah.
Been moved and seconded. Any further discussion? All in favor?
I,
Aye. All opposed? Motion carried. Okay. Any other, well, we can't have any other business, so. I guess that concludes our hearing, so. I'd like to thank staff, I'd like to thank the planning commission members who are here, and I'd like to thank the applicants for coming.
Before you close, just a procedural issue. Dan, do they need to do the first reading of the ordinance 2024-06 or just state that for the record? Amend the
I don't know.
motion?
I don't know what your practice is. It's a little painful to read these things. Oftentimes you can read them by title only.
By title only, yeah. So as part of the motion to approve the package, could they also make a motion to approve ordinance number 2024-06?
Okay, I think, yeah. I mean, that's the vehicle for adopting this text amendment package, right?
Yes, and then the second reading is 2 weeks from today.
so we need a motion for the.
I think just to make it
Adopted
clean,
resolution.
yes,
Did you get that?
the ordinance, it's ordinance, not resolution.
Ordinance, so make a motion to adopt ordinance 2024-06.
Yes, perfect.
Second,
Second,
with a reading by title,
Okay.
correct?
Yeah, with the changes that were just described.
With the changes described.
Yes, okay.
Yeah.
so, yes,
We don't
further
have to do that.
discussion, all in favor?
Aye.
All opposed? Carried. Okay. Anything else?
No,
No.
no,
Yeah, It's like the afternoon, we're putting one day, so it's fun, make sure we got everything that we want. Anything running around, okay. All right, thank all of you, everybody.
Thank you.